All right, thank you all so much. Thank you for braving the rain to come out here. Does that look okay on the screen? I can't see it, obviously. Yeah. Great. So I'm Jonathan. Basically, I have the unenviable job of talking about mass surveillance and kind of the larger perspective, as well as the technology that we mentioned a little bit, but also that's enabling kind of some of this stuff. So when I say mass surveillance, what am I talking about? It's a very specific definition that I'm using from the UN, actually. And they define mass surveillance as a situation in which states with high levels of internet penetration can gain access to telephone and email content of an effectively unlimited amount of users and maintain an overview of internet activity associated with particular websites. The UN report summarizes that to say that all of this is possible without any prior suspicion related to specific individuals or organizations. So this is what we've seen created by a number of different governments at this point, and this affects attorneys here in the US. We've seen large law firms like Mayer Brown in Chicago, which is a global firm, have their information taken during negotiations that they were in with representing the Indonesian government against the US government in trade negotiations, and their internal attorney-client privilege information was taken by the NSA as part of the NSA's mass surveillance and used against them in litigation. We have US-based attorneys generally, and then we also have some of the encryption tools that attorneys have relied on in the past that have also been undermined by this sort of mass surveillance spectrum. We also have seen specific attorneys targeted, so Muslim American attorneys as a whole have been targeted with mass surveillance in specific. This has been folks like Faisal Gill, who's a longtime Republican Party operative who served in the DHS under Bush with security clearances and is on FISA's specific targeting list, which is the information court that authorizes the kind of more targeted surveillance. And then people like Niad Awad, who's the executive director of CARE, which is the largest Islamic American charity in the country, who also is on that same list. There's a whole laundry list of folks there, but I just want to point out some specific ways in which this does affect people in the current moment. And then we've seen this also being used in kind of normal criminal matters, so it's not just a national security issue, it's not just kind of a large question of, but it's in everyday criminal stuff. So this is, there's a whistleblower, a prosecutor that blew the whistle in Florida on a practice that the federal government is now investigating, but basically it's called parallel construction, where the DEA and other federal agencies will re-engineer a criminal case to remove the evidence of electronic monitoring. This is considered a bedrock legal practice on the part of law enforcement. So they did that in a case, and he got the DEA agent to admit that the witness was a manufactured witness, and then was able to have the case thrown out, and that the evidence originally was actually based on NSA intercepts in a drug prosecution that was happening in Florida. Right? So this is, and this is widespread. There's a $125 million unit of the DEA. It's called the Special Operations Division, or SOD, that works with 24 partner agencies, including the FBI, CIA, NSA, to do this practice. Right? So this is a way in which this undermines the Sixth Amendment. The defense bar has been pretty adamant about the fact that this is taking away the ability of a defense attorney to see the evidence in trial and where that evidence is coming from. But at this point, we have not heard in terms of if there's been any change around the way in which this is violating the Sixth Amendment.
Okay, so I think the first question that is worth talking about, since this is about ethics, is the one that Jonathan raised, which is, should the ethics rules be more specific than they are? Right now they require that we have a reasonable understanding of the law and we take reasonable measures. And after these presentations, I got to tell you, I don't know what the reasonable standard really is. So maybe that tells you something about my position on this. But so Jonathan, why don't you stake out your view that it should be more specific, and what should it say?
Sure, thank you very much. So I think it's very important to be specific in this case because it is so complicated, and there's so much possibility with the technology and change, and we've seen leaps and bounds every year in terms of technological development. And the things that need to stay consistent are the reality of the technology in terms of what's possible with both the math that encryption involves, as well as the computing technology that offices are constantly using. And unfortunately, without that kind of specificity, we end up with a situation where, there was just an article, Super Lawyers did a thing, it was an advertising supplement in the New York Times where they talked about this kind of issue around privacy just the other day. And then they have a what you can do as a response to this as super lawyers. And basically it's check your online accounts frequently and look for signs that something is wrong. So they have 3 bullet points, that's their top bullet point. That's not helpful information for most attorneys. Unless you have a huge amount of information security background, you have no ability to assess whether or not your information is compromised with a idea like that. And so the other one is get a copy of your credit reports every year and look for errors. Okay, that also doesn't address any of these issues. We need clear guidelines for attorneys as a profession, and these are the correct ones to say provision of end-to-end open source encryption for private information and at client request. This is already required by Massachusetts law, and New York attorneys should be doing it for Massachusetts residents. Or you could be sued by the state of Massachusetts if you lost Massachusetts residence data. You should screen your clients to see if they're Massachusetts residents, and then you have to encrypt their information both at rest and in transit if they are Massachusetts residents. That's the current state of the law. We should be bold and clear about this for the state as a whole and saying that we are out in front on this and we don't need the legislature to tell us what to do, but we actually can regulate ourselves as a profession and take a proactive and thoughtful stand around ensuring that our clients can have trust in us, especially in New York, because we are so international as attorneys. We're dealing with international clients all the time. They need to have faith in our ability to do work, and that they don't have to worry about our government undermining our ability to have a trusting relationship with a client who may or may not have the protections of citizenship.
So can I ask a follow-up, and then I know that there are folks on the panel that have a different point of view. So if the language says it has to be encrypted end-to-end, do we really know what the word encrypted is? Do we really know, right? So you said proprietary encryption is not good enough. So would you have the rule say it has to be open source encryption? So you would be that specific. Okay. So I think we have some people down the table who take issue with that approach.
Yeah, I would definitely also be in favor of open sourced encryption products. They're not to say that they're without fault, again, and they're situation specific, but there are ways to even support. I would say if the people developing the tools that make this open source encryption easy to use had a minuscule percentage of the budget of firms like RSA or Microsoft for that matter, they could do really amazing things.
And the question is that I pose back, yes, if you're Paul Weiss and Davis Polk and larger firms where you have dedicated IT departments, it may be very easy, okay, to change in real time as the technology changes. But for those of us who don't have those resources, how do you really say to small firm practitioners, A, you have to use encryption? 2, how do you say to our clients in turn, they have to understand and learn encryption? Because I'm sure for many of you sitting in the room, whether it's foreclosure work, bankruptcy work, personal injury, immigration work, etc., right? Many of those clients don't have cell phones, okay, don't have computer savvy tech know-how, and for all of a sudden us to be burdened with that additional requirement of having to, in a sense, teach our clients about technology, is that really fair to the other part of the legal community which isn't in that larger firm environment, and sort of how do you deal with maybe the equities of it in that respect?
So I think that's an excellent question in laying out kind of the difficulty of this, but I think that in this case, actually, it's pretty clear. Large firms already, for the most part, require encryption for. I've been working at a large auditing firm, or had been working there, and you're not allowed to send email that goes outside of their network. Like, you have to talk to someone about doing anything that goes outside of their network, and it has to be encrypted. So large firms are already doing this. So what we're seeing is a two-tier system of law, where we have large firms that are encrypting everything all of the time, and then we have small firms that end up with not being able to maintain the trust of their clients because they can't tell whether or not their systems are secure. We need a system of law that provides accurate representation. This is what the rules are designed to do. So we need to make sure that every attorney is able and prepared to secure the trust of their clients. If they're not able to do that, then they are not an attorney. They're not up to the rules that are required. We need to ensure that that happens, and we can do that with the simple change. And this is the correct technical and ethical question of open source encryption, because it also is free. It is not actually a burden. It actually assists your clients in terms of that, because they now have an ability to communicate. If they're not able to do that, they can write you a letter and hand it to you. I mean, there's other options. We're talking about digital technology, but I think that there's a requirement for personal information to have it encrypted, because otherwise we'll see those people's data. I mean, if the director of the CIA just got his email hacked, if that was encrypted, his information would not be out online right now. If this is something that's a problem for the director of the CIA, it's a problem for society as a whole, and we need to ensure that everyone has a provision of legal services that they can trust.
I agree with the ethical rules the way they are. There's a responsibility in new model rules that you stay educated and up to date with technology. That's clear. So if we keep doing that, however that happens to be, if you come to NYCLA or if law schools change their curriculum, I think that it's going to work their way. And I'm happy about John and Peter, because I like these guys. They're pushing the thing along. That's the way it's going to work. You have that undertow of pushing the thing along. So the combination of those two things, I think, is going to get us to a good place.
Thank you, Joseph. And as you were saying, I mean, I thought it was remarkable that at the big banks, they constantly have data breaches, right? I think that is a thing that we need to take seriously as a profession, and realize that we are failing our clients currently. We are not living up to what they need in terms of securing their information. I know that's hard to hear, but in asking attorneys and in doing these trainings, consistently, attorneys are being undermined in multiple ways, and we're seeing this more and more every day. This is a crisis of data insecurity, and attorneys play the key role in ensuring that both we can have a society that doesn't become totally surveilled all the time, and having a society where people can trust professionals to effectively represent them. This is what this issue is about, and we need to change the attorney-client requirements. All we need to do is change reasonable effort to be defined as provision of open source encryption that is end-to-end. That's a simple statement that will go way downfield and keep us secure as a profession for dozens, if not hundreds of years. And new attorneys coming up need to have education on this. This is a way to ensure that law schools educate attorneys on this, so that we don't see the kind of data breaches that we've been seeing in the last year or so, and that we don't end up with a government that is constantly surveilling all of us, undermining the ability for clients to have trust in us. This issue of trust is the fundamental that is the only reason why clients come to attorneys. If we can't honestly look a client in the eye and say we know how their information is secure, we do not have an ability to assure them trust. And if big banks can't do that, then we know that the vast majority of people here in the room cannot do that at the current moment, and I'm sorry to say that. I know I can't do it unless I'm using encryption, right? So this is something that we have the ability to do, and we need to rise to the occasion and take leadership in ensuring that our profession can maintain the trust of clients.
Thank you.